This House in session.
Is to move the second reading of the Supreme Court of Judicial Amendment Bill 2019.
Member for St. Joseph.
Mr. Speaker, there are occasions when one has the distinct honor of moving an amendment to a piece of legislation that has the potential to, if not completely transform, and I wouldn't even claim that it could do that, but certainly go a long way to transforming the currently dismal state of the delivery of justice. I know that some people might consider such an opening gambit to be unduly harsh, but I am not known for being hypocritical. On the opposition benches, on numerous occasions over the last decade, I have felt compelled to publicly complain about the delays and inefficiencies that are now endemic with and to our judicial system. It is not a new lament of mine. And I assure you, Mr. Deputy Speaker, that it is not a lament that I could ever have taken any comfort in, because I would not be in this ministerial portfolio if I was not a member of the Bar of Barbados. And the inefficiencies in the judicial system are not caused entirely by failings of our judges. In part, they are caused by inefficiencies and failings among the members of the legal profession and by the many other structures and individuals that go to make a judicial system work. We have been honored in Barbados to have had, for every generation, some of the most brilliant judicial minds in the world. And for many years, distinguished jurists, born and bred in Barbados, have served abroad. They've served in high office in England, high office across the Caribbean, high office in Africa, in fact, high judicial office across the entire Commonwealth. We've had Barbadian-born jurists who have risen to perhaps the highest levels of academia in England. We've had Barbadian jurists who have served on international tribunals with tremendous aplomb. And so, sir, it is not an argument that could be made that we do not have quality judges in Barbados. But there are some realities that I must also point out that bedevil our system. Mr. Speaker, much of what we do today is still paper-based, and that in itself is inefficient. This morning or this afternoon we made an amendment to the standing orders which will allow electronic laying of bills. All across government platform we are moving towards electronic filing of this, electronic filing of tax returns. We are moving to a digital format. But yet still, Mr. Speaker, if I want to file documents in the High Court, somebody has to walk across to the registry, stand in a queue, produce a revenue stamp, and deliver his documents to a clerk at the registry. A process that will take and could take as many hours as 2 or 3 or more, depending on what is happening at the registry. When in the highest court of the land, if I want to file a document in the CCJ, I can file it at 1 o'clock in the morning, sitting in my pajamas, and I don't need...
You sleep it down?
Remember for St. Thomas. Mr. Speaker, but the point is that there are some inefficiencies about our system. Now, they worked well in the past, but we have to get rid of them now. So I don't want to come to this chamber and lay blame at the foot or the feet of judges, but there are some harsh realities, sir. Firstly, the judicial arm of this country is one of the 3 constitutionally recognized branches of government. And politics 101, you have the executive, which are the members of the front bench and the public service and so on. You have Parliament, which is all of us. And then you have the judiciary. The judiciary, sir, is so sacred to the political landscape of all democracies that they have something called judicial independence and security of tenure. In fact, under our law, and it came up recently in a case in Trinidad involving their Chief Justice, where the court had the opportunity to discuss how you get rid of a judge. The Trinidadian jurist pointed out that you can only get rid of a judge at the end of a tribunal process and for misconduct. You are not allowed under the Constitution to change the terms of a judge other than improving them. You can improve them all you want, but you can't change them to their detriment. For the simple reason, sir, that when a judge deliberates on a case, he or she must not be influenced by external forces and opportunities. And that's why our judges have state-provided vehicles. They are, some would consider, well paid. And they serve without fear of any kind of detrimental action being taken upon them. But the reality is, sir, that to whom much is given, from him much must also be expected. The bar has recently provided to the Chief Justice a list of outstanding decisions. And there'll be another occasion, sir, to deal with that. But there are some judges who have decisions outstanding for 1 year, 2 years, 3 years, 4 years, 5 years, and in some cases 6 years, sir. And I reiterate, Mr. Speaker, that these are matters that I am not now speaking of when I know that I am in the Office of Attorney General. I was speaking of them when we were on the other side. Mr. Speaker, my constituents need to feel that there is a system of justice that works in equal measure for the rich and for the poor. My constituents deserve to feel that their disputes, perhaps with their neighbor or perhaps with corporate Barbados, will be dealt with dispatch, so that 6 and 7 years down the line, they're not still waiting on a court to give a decision. I accept, and perhaps that is the basis of this statute today, I accept that with the number of court cases that are filed numbering in the thousands, and the complexities that are now attended with these cases, that it is necessary for us to make changes to how we deal with our judicial officers. And we are coming to Parliament today, Mr. Speaker, to increase the number of judges from 8 judges to 13. This is not something that we do without serious consideration, because to add another 5 judges to the bench comes at tremendous cost, not just in terms of physical space, but staffing and the very cost of engaging those judges. But, Mr. Speaker, what is the cost if we don't do it? One of the things that encourages people to come to a jurisdiction is the rule of law. But the rule of law means nothing if you have to wait 6 and 7 years to have your case dealt with. Mr. Speaker, I was involved in a piece of litigation, and in that matter, we were able to get a judgment for my client. The other side filed an application to set aside that judgment. The judge heard the argument, sir, and 5 years later, the judge has still not given his decision. Mr. Speaker, I have written the Chief Justice. I have written the judge personally. I have raised the issue with the Bar Association. Mr. Speaker, I have been polite. I have been impolite. I have pleaded. I have begged. My client was a younger man then, but he's a far older man now. But the worst thing of all about it, sir, is that this is what we would call a judgment on an interlocutory application. So what that means, Mr. Speaker, is if the judge decides to set aside the judgment, the case now has to go to trial. The case now has to go to trial. And 5 years hustling hard to 6, and that judge has still not given his decision. Mr. Speaker, there is no world in which that could be considered acceptable. The Caribbean Court of Justice has spoken in angry and critical terms of the delays in giving judges, of the delays by our judges in giving decisions. If judges don't decide, then what is the point of being a judge? But we're not going to stand and criticize them, sir. We understand that. But so what we're saying is, if the workload is too much, we're going to increase the number of judges. Now, I've always been known to be fair, Mr. Speaker. In 2018, 246, as of November 26, divorce petitions were filed. As at the same date, 1,838 civil applications were filed. At the same date, 243 indictable matters were brought before the court. And that does not include, sir, other kinds of applications like bankruptcy and others. And, sir, between 2011 and 2018, 15,000 civil cases were filed, 3,347 divorces, and we know that we have probably somewhere between 1,000 and 1,500 criminal matters waiting to be tried. Now, Mr. Speaker, with the best will in the world, there is no way that our 8 High Court judges would be able to rule on those matters. And every year, sir, another 2,000 or 3,000 getting added. In the year 2015, the report of the Judicial Council of Barbados shows that 36 judgments were written. 36. And in that same year, over 2,000 cases were filed. Sir, we last increased the number of judges in 2003. And in 2003, sir, we moved the number of judges from 5 to 8. In 2003, those 5 judges, up to 2003, those 5 judges would have heard all of these cases, and they would have constituted a divisional court to deal with appeals from the magistrates' court, and then would have constituted themselves a court of appeal to deal with local appeals. And strangely enough, sir, in 2003, the number of cases is very much like the same kind of numbers that we have today. But there's no point us criticizing unless we put solutions. And I'm happy to put this solution before this Parliament and the country. So, just to repeat, we're moving the number of High Court judges from 8 to 13. As part of that 13, sir, we will be, and by this statute, creating a dedicated commercial court. There are a large number of matters that go into our existing judicial apparatus, and because of the inefficiencies, the amount of time it takes to get out of the court system is long. Now, the problem with that is, sir, that you will have commercial decisions that need to be made quickly, but cannot be made quickly because the matters are in the High Court for years. Another area, sir, is family court. There are family applications that are dragging on for year after year after year after year, when the whole idea of a family court is to bring an end to the arrangements between the parties. So what we are planning to do, sir, is to create a commercial division which will deal with such things as bankruptcy and insolvency. It will deal, Mr. Speaker, with, in fact, let me give you a synopsis of the schedule. The commercial division will deal with business documents and contracts, exports and imports of goods, carriage of goods, the exploration of oil, gas reserves and other natural resources, insurance and reinsurance, banking or financial services, the operation of financial markets or stock exchanges, purchase or sale of commodities, matters relating to admiralty, business agency, matters relating to arbitration, matters relating to bankruptcy and insolvency, and matters relating to intellectual property. Sir, in many countries of the world, these dedicated commercial courts are highly specialized courts, and they're intended to see speedy resolution to business and commercial matters. Mr. Speaker, I'm sure there's many a businessman out there who will tell me immediately that they have had a substantial case in the court and it's been going on for 5 and 10 years. People have to make decisions on investments, whether to expand businesses or not. But they all need to be satisfied that the court system will be responsive. But then there's the other side, sir. We intend to increase the number of permanent criminal courts. And in this new paradigm, Mr. Speaker, this additional 5 judges will allow us to have 4 fully dedicated criminal court judges on a permanent basis. Now, sir, I promised that I would not delay the chamber too much, but allow me to say this. So far for the year, Mr. Speaker, we've had 9 murders. 4 of those murders involved the use of firearms. Last year, I think the number of murders was 27, and about 17 of those murders related to firearms. People have been talking about a spike in murders, and perhaps I should save that discussion for another day, but the point is, sir, that our society is rightly concerned about the viciousness that is attending the criminal element in Barbados. And we are therefore obligated to move swiftly, sir. Now, it's one thing for the police to arrest a man within weeks, but when we can have over 1,000 matters on indictment awaiting trial, that have been accumulated over 10 years, then we can have a situation where individuals charged with murder are successfully applying for bail, when individuals charged with serious firearm offenses, possession of 5 and 6 submachine guns, applying for bail, and the circumstances are such that they cannot really expect a quick trial in this environment. It tells you, sir, that we need to make sure that we do all that we can do to ensure that accused people have their day in court, but that they have it quickly. That is vital, sir. A lot of the bail applications that our judges feel compelled to grant would not likely be granted if accused were assured of being able to have a trial done with all possible dispatch, and in some jurisdictions within 6 to 9 months. But sir, with over 1,000 criminal matters on indictment awaiting trial, and only 2 criminal judges at any one time, sir, when do you finish? When do you finish? So we are going to have a permanent criminal bench of 4 judges, and I hope that it don't need to be permanent as in forever and ever, but it is going to be permanent until such time as we see the number of criminal cases reduced, whenever that happens. In the short term, we're going to be appointing temporary judges to deal with the criminal backlog. And in fact, sir, you can say to the chamber that 2 new physical courtrooms intended specifically to accommodate the criminal judges have been constructed as part of the refurbishment project. Now, that will therefore leave us, sir, with an additional 4 judges who will do all the rest of the civil matters. But the increase in the number of judges is only one part of this exercise. For a long time, Mr. Speaker, the political class in Barbados has had the appointment of judges grasped firmly within their hands. And I think it was in the 1976 Constitutional Amendment, 74 Constitutional Amendment, when the Right Excellent Honourable amended the Constitution, which provided at that time for a Judicial Service Commission to hire judges to make the appointment of judges something solely within his purview. There was a lot of talk by the then Barbados Labour Party. The Barbados Labour Party at the time was dead set against it. And in later years, we were rightly asked, well, how come you were so dead set against it? And said it was the worst thing in the world and would lead to all kind of political manipulation, and you didn't step in to change it. And I'm sure that people are still making that argument against us, even now. But as I've said, and other members of this chamber have said several times today, if there's one thing that separates this Barbados Labour Party administration from any previous Labour Party administration, is the fact that we are not afraid to take decisions which change the way in which we do things, and to take decisions which some may consider hamper us. What do I mean, Mr. Speaker? For the first time, I wish I could say even louder, for the first time, sir, in 50 years, maybe a little less, the post of judge will now be advertised.
Right there.
Will now be advertised, sir, not just in Barbados, but across the entire Commonwealth. And we can talk about that, because I know some people may feel a little bit worried about that, sir. But let's take it in small bites. We need to attract the highest caliber of individual to the bench. We need to open up the categories of individuals. We need to open up to the class of individuals who are interested in serving on the bench the opportunity to do so, sir. I have been a lawyer for almost 30 years, and there have been days when I would wake up one day and see in the paper that John Brown is appointed to the bench. There was no advertisement. And I have been on the front bench, and there were times when Jane Brown would have been appointed to the bench. No advertisement, sir. There was a time when it was felt that only members of the public bar, meaning government lawyers, should be elevated to the bench. Private practitioners weren't considered. None of these were transparent arrangements. But, sir, for the first time in our history, any vacancy for judge in our judiciary, whether High Court or Court of Appeal, will be advertised in Barbados, in the Caribbean, in CARICOM, in the Commonwealth, sir, as far as Australia, everywhere in the Commonwealth. Now, sir, you know, Barbadians have been known to be a peculiar people. We are very happy when Barbadians go to Bermuda and serve with distinction on Bermuda High Court bench. We are happy when Barbadians, current Governor General included, go to the OECS and serve with distinction on the OECS benches. At one point in time, sir, we had 2 Bajans on the OECS High Court bench. And in fact, you could call it 3, because some consider Bermuda to be part of that OECS circuit. We have had Barbadians who have been Chief Justice of African states, post-independence. But somehow, sir, the idea that somebody from outside of Barbados could come and deliver justice to Bajans is something that has always galled us. It has always galled us. It is all right to have a Guyanese judge come to Barbados and work in the DPP's office as a prosecutor. It is all right to have non-Barbadians come in and work in our magistrate's court. But somehow, sir, you know, non-Barbadians come to Barbados and do all kinds of things. But somehow, sir, when it comes to making the best decisions for the highest court of our land, our High Court, we seem to be skeptical about it. Mr. Justice Andrew Burgess has now left Barbados' shores to become a judge in the Caribbean Court of Justice. And who is sitting alongside of him in the CCJ, sir? Mr. Justice Hayton. Mr. Justice Hayton, I read his law books when he was a student, a famous equity lawyer from England. And DeWitt, a Dutch-trained lawyer, all of whom have come to bring their own experience into the crucible of what is now the Caribbean Court of Justice, sir. For myself and for this administration, I say that we do not balk when it comes to bringing the best skills to our shores. But, Mr. Speaker, I want Bajans to be on our court. Let's make that clear. We all want Bajans to be on our court. Some members of this chamber may aspire to be on our court. But the point is, sir, that there's some realities that we have to face. As big as we say our bar is, only 10% of our bar are Queen's Counsel. And of that 10%, Mr. Speaker, very few of them are interested in judicial office. So what happens is that you have, well, some of them shouldn't be, but that's, I wasn't involved in that decision. And anyway, let me keep quiet on that score, sir. So, you know, we as big as we think our bar is, our pool for judicial officers is small, plain and simple. And I can see absolutely nothing wrong, sir, with opening up for interests, members of the legal profession who work across the OECS, members of the legal profession who work in the Commonwealth. So, 2 things, sir: judicial appointments, or opportunities for judicial appointments in the High Court and the Court of Appeal, are going to be advertised from now on. Mr. Speaker, we have 3 judicial appointments to fill in the Court of Appeal. They are going to be advertised. Plain and simple. And if those individuals get bumped up, if individuals who are currently acting get bumped up by virtue of that transparent process, then we will have high court positions to fill, and they too will be advertised. So that is the lay of the land going forward, sir. So the days of wizzy in the back room and trying to lobby for your son or your daughter to be appointed to the bench, and somebody saying that so-and-so got some arrangement with another person, those days are gone, sir. Completely gone. But how do you make the selection? Mr. Speaker, we are establishing a selection committee. And that selection committee, Judicial Appointments Committee it will be called, will consist of the following, sir. The Chief Justice of Barbados will serve as an ex officio member of the committee. That is, by virtue of being Chief Justice. Next, at least one person who is a former justice of a court referred to in Section 79C of the Constitution, sir. Section 79CA of the Constitution refers to a member of the Caribbean Court of Justice. So a former justice of the Caribbean Court of Justice will be on this selection committee, sir. At least one person who is a former Chief Justice or a former Court of Appeal judge of Barbados. A former judge of the High Court. A member of civil society. And an attorney at law 10 years standing who is a member of the bar. Now, Mr. Speaker, let me tell you about the civil society. There are some who feel that the process of engaging a lawyer is something that only the high and mighty can do, you know. But this selection committee is going to be appointed by the Prime Minister, so I won't presume to tell her what to do. But I like to think, sir, that there is great merit in not limiting the choice of who should come from the civil society. It may be somebody who it may be a political activist, it may be a church member, but it might be somebody from living next door to your mother or your father. We can't rule out those people, sir. And this selection committee will be responsible for advertising the posts. They will be responsible for interviewing and vetting the individuals and then making the final recommendation to the Prime Minister, and the Prime Minister would thereafter make the judicial appointment. Now, Mr. Speaker, as strange as this may sound to some Barbadians, it's not new. It's not new because for the longest time across the Commonwealth Secretariat has actually been trying to formulate rules to deal with the appointment of individuals to high office. And those rules have come to be known, Mr. Deputy Speaker, as the Latimer House Principles. And these Latimer House Principles emphasize the separation of powers between the three branches of government, the executive, the legislature, and the judiciary. And it says that vital to this separation of powers is the independence of the judiciary. But for a judiciary to be independent, there must be independence in the method of appointment. And if I might quote from the relevant section of the Latimer House discourse, sir, it says that an independent, impartial, honest, and competent judiciary is integral to upholding the rule of law, engendering public confidence, and dispensing justice. The function of the judiciary is to interpret and apply national constitutions and legislation consistent with international human rights conventions and international law to the fullest extent permitted by the domestic law in each Commonwealth territory. It goes on. To secure these aims, judicial appointments should be made on the basis of clearly defined criteria and by a publicly declared process. This process should ensure equality of opportunity for all who are eligible for judicial office, or for all who are eligible for judicial office. Appointment on merit. That's the second bullet, sir. Appointment not on who you know, not on who your friend is, not on who your girlfriend was, not on which district you came from, not on whether you come from St. Philip or elsewhere, sir. It emphasizes appointment on merit. And it goes on, sir, to say that appropriate consideration must be given to the need for progressive attainment of gender equity and the removal of other historic factors of discrimination, sir. Those are the Latham House rules. So, sir, in the year 2019, this Parliament, led by this Cabinet, is being asked to sign on to a completely different trajectory for the appointment of our judges. That we appoint judges in a fair and open process, and that the appointment must be on merit. Those are the things, sir, that will help us to remove any stain from the previous manner in which judges were appointed, and it allows us, sir, to ensure that we attract to the bench the highest quality individual. And there are things that flow from that, sir, because when you have the highest quality individuals on the bench, you will also be able to get the highest quality service from the legal practitioners. So this is a vital thing, sir, and I am honored to be the Attorney General who puts it on the table. Mr. Speaker, let me make it clear that I do not intend to suggest in any way that any of the currently serving members of our bench, whether acting or otherwise, and who may have been appointed or who must have been appointed by the former process, are not from the elite in legal intellectual circles. I do not in any way want to suggest, sir, that they are not of the finest judicial minds. I certainly will not suggest and cannot suggest that there is any lack of independence of the judiciary. But, Mr. Speaker, the byword of everything that we have done since we became government on the 24th of May last year was and has been transparency. And some people may say, man, you're real foolish. The Prime Minister ought to be able to call up so-and-so who, man, I hear he's a B, we should give you a pick on the bench. I've heard that. People have come to me and said, man, you know, so-and-so, man, so-and-so is a B. Man, you gotta make sure and sort out we people. You know, that's what I'm being told. And I'm being vilified when I tell them, you're talking the wrong man. Talking the wrong man. But that's what people are telling me. We should put so-and-so on the bench because so-and-so is a B. And the last judge or whatever judge that got appointed was a D. And the D's put him on, so we got to try and sort out our people now. Mr. Speaker, the problem with that kind of system, sir, is that the only where it takes you is down. And they did not get elected in the last election to carry our country any further down than it already was. And moving up is never easy. Moving up is never easy, you know. It's uncomfortable. Half the time it's unpopular. You get people confuse you. They don't like you because of the decisions you're making, sir. But in every instance, as long as we stay true to our fundamental principles and are honest with our people, sir, I believe that our decisions taken for proper motives will always be the right ones. Mr. Speaker, there are more changes to come, but it is a little late in the day, and we have labored mightily and long in the vineyard of the Parliament of Barbados. I believe that this change is welcomed by the bar. In fact, I have canvassed many members of the bar about this, sir, and the members of the bar are delighted because you know what, sir? For some of them, it represents an opportunity to even apply for the post of judge. Because you just didn't know. No, I have to tell you that temporary appointments will be unchanged because temporary appointments to act and so on, somebody who's going to act for 3 weeks or 4 weeks, sir, you have to do it in the ordinary course of things. We are going to be bringing on a few temporary appointments to help us to deal immediately with the backlog until we get the permanent judges put in place, because obviously if we're going to be advertising the committee has to be selected and approved by Parliament. Then they have to put ads in the papers. Then we have to, those ads have to come in, be vetted and shortlisted, and then we got to do interviews. And then, of course, if somebody in Barbados gets the job, fine. They may only need a month to 6 weeks to wrap up what they're doing. But if it is somebody from Jamaica or somebody from St. Kitts, sir, that person may have to think about relocating their family. So it'll be a little while before those people can hit the ground running. But it is something whose time has come. I'm not going to, I believe that there'll be other opportunities, Mr. Speaker, to talk at greater length about the judiciary. There are things that concern us, but you know, other times will arise for those discussions. Mr. Speaker, as I said, this represents a total transformation in how we deal with the appointment of judges. I believe it augurs well for the bench. It augurs well for its credibility. But I have to say, sir, that I remain disappointed. I remain very disappointed, Mr. Speaker, at the fact that this backlog continues. It is causing a hardship on people who have become frustrated with the judicial system. If there's nothing else in the country that works, sir, it has to be the judicial system. No matter what else happens in the country, sir, the one thing that keeps you in the realm of being civilized is that the rule of law is there and it is applied. But Parliament does not apply the rule of law. The executive does not apply the rule of law. If a person gets unfared by a government minister, he ought to be able to feel that he can go to the courts of this country and get justice. There are cases, sir. The case of there are cases in Barbados relating to the police force, and the cases are not finished yet. But the fact that they're not finished has presented difficulties for the hierarchy of the force because they're not sure what appointments they can and can't make. These are the kinds of things that affect us. There are neighbors who have disputes, and the courts are not settling them, sir. The judges have to do their duty. Every single one of them, sir, signed on to a code of conduct. And that code of conduct says that they will deliver their decisions within 8 months. They don't have to like me. True. Whenever I leave politics, I'm going to go back to my profession, and like me or not, they have to deal with me then, because I will have a right of audience before every single one of them, sir. And when I said it when we were in opposition, I didn't care if they liked me then either, because I'm not speaking on my own behalf. There are poor people in every single constituency of Barbados. You represent them. Member for St. Michael West represents them. And somehow or another, they feel that they can't get justice. They feel so. And then we wonder why they're cynical. We wonder why they lose faith with our institutions, sir. The judiciary of this country is in a privileged position. It is a great honor to be asked to serve and to dispense justice in any nation. If you go as far back as the Israelites, they had their judges. The member for St. Peter should be nodding that eye. If I'm wrong, no. If I'm wrong, I mean,
the Christian gentleman.
The Israelites had their judges, sir. But that's what judges do, and that's what judges are. And you sign on to it for better or worse. You know, the member for St. Thomas tells me that her day does not end sometimes until 11, 12 o'clock. Because she has constituents who have reposed their faith and their trust in her. So she doesn't get to take a day off. If she goes in the supermarket, Mrs. Deputy Speaker, and a constituent walks up to her, and they say her, but it happens to all of us, doesn't it? Yep. They walk up to you because they say, you know, he like you. Yep. And this is my question, Bishop Hatherley. This is my question, Mr. Jordan, Mr. Griffith, Mr. Strong, Mr. Duguay, going to money?
money.
But the point is, sir, that we have chosen to serve, and serve we must. And if we do not serve, what happens? The very same things that happened to 30 Democratic Labour Party representatives in the last election. But there's no recall for a judge, there's no voting out for a judge, there's no getting rid of a judge.
Oh?
Nothing so.
Can't get rid of a judge?
There are constitutional provisions which are very strict and very restrictive in order to be able to remove a judge if he or she does not do the work. In fact, you can't even remove a judge for that. The judge has to be guilty of misconduct, not even not doing the work. And as they said, they know they're not going to like me, but that's not what I'm here for. That's not what I'm here for, sir. But they have privilege, they have constitutional protection, and in the same way that everybody else has to do their job to the fullest, judges have to give decisions. Plain and simple, sir. Plain and simple. I admire them for the sacrifice they make, because when the member for St. James South and St. John decided to go in a rum shop with me, you're not going to find a judge there, because you're not going to find a judge there. It might be nice, but you're not going to find a judge there. Because one of the hallmarks of being a judge is that you must be of sober temperament, and by sober, I don't think that they may not consume alcohol. But there are certain restrictions that a judge can't do. A judge would probably love to go and jump at crossover, but can't. So there are challenges to it. It's not all easy.
I know one who does, though.
But sir, I'm begging them.
Oh, Lord.
I'm begging them, sir. I'm begging them from this chamber. I've told them that I am going to give them every single thing that we can humanly give them. I've promised them that. The Prime Minister has said she will make the resources available to make their lives easier. But they have to do their duty by the people and deliver their decisions. We want to see the length of time for trials to be completed in the criminal jurisdiction down to 6 months. Down to 6 months. If you're not guilty, you get up, but if you're guilty, you go up and serve time. And we want to see the disputes that exist, the civil disputes between our neighbors and brothers and sisters and businesses and customers resolved in 6 months too. And let's move on, sir. One Caribbean jurist noted that cases represent a reservoir of state assets, not state assets as assets belonging to the government, but it represents a reservoir of assets that are locked up because of failure to decide. But the moment the judge decides, unless the parties appeal, those assets can be released. So if somebody has a case with a personal injury claim, and they claim $30,000, if that case takes 10 years, that's 10 years that that body is out of the $30,000. Sometimes they're dead. But the moment the decision is given and that money is released, it's released sometimes to pay bills, to make an investment, to get turned around, to go and buy a new fridge, to fix the step, to fix the back door, to put in 2 new windows. And the similar things happen with commercial enterprises. A lawsuit that might involve $20 or $30 million, when it's resolved, sir, it releases that money from being locked up. So, Mr. Speaker, I'd love to stay and talk longer, but I think it's time for me to shut up. I believe, Mr. Deputy Speaker, that this bill represents an opportunity for us to signal to the judiciary that we're going to give them additional manpower to stand beside them and to help to make their load easier. We came to government saying many hands make light work. That applies to the judiciary too. So I am making sure that the judiciary has the many hands they need to help to make the work light. But for heaven's sake, please deliver some judgments. I'm obliged to you.
Thank you. Members, please stand for the rebel of the Speaker.
Honourable Member for St. Michael West.
Thank you very much.
Read a second time, sir.
Second that, sir.
Thank you very much, Mr. Speaker. Perhaps just briefly, I would want to say a few things with reference to this important bill before the House. The Honourable Member for St. Joseph rightly underscored the importance of the judiciary as a third major plank in our architecture of democracy. In fact, he seemed to suggest that is the most important of the three branches of government. That is arguable, but that's an argument that can find support. And I want to support this bill and the attempt to improve our system of dispensing justice in Barbados, because I do truly believe it is critical that we get this working as efficiently and as effectively as possible so that we can secure the gains already made socially, economically, politically, and that we can aspire to greater gains in a context where we believe that justice is properly and fully administered and accessible as widely and as universally as possible to Barbadians. If I suggest that justice is more than simply what happens in the courtroom, I would want to imagine that that is a statement that would be readily accepted even by those who are practitioners in the courtroom. The whole world of justice is bigger than the world of the courtroom. We can't fully and properly address the deficiencies in the system simply by appointing more judges. Although I want to make it clear, I am supporting this appointment of these additional judges, as I understand it, 5. But we've got to look at the whole business of the administrative context in which those judges, now numbered and increased potentially by passage of this bill and recruitment of such persons, we have to look at the whole administrative context in which they serve the court system and therefore by extension serve the people of Barbados. We understand that we cannot continue with the business of piecemeal approaches, but we equally understand that jurisdictions such as ours, economies such as ours, are constrained financially, our capacity limited to do fully and properly what we ought to do in order to attain the goals we set ourselves. When it comes to the administration of justice, this is a consideration not to be exempted. We do not have the funding, irrespective of the good intentions of the Attorney General, the Honourable Attorney General and the Honourable Prime Minister, to provide whatever is needed by those who will be recruited additionally to these posts. We do not have sufficiently so the wherewithal to do all those things that we know need to be done. And the result of that is often what one might call a piecemeal approach to addressing the situation. That is not to be negative on the initiative being attempted here by the government. That is to cite a reality. We do not have the financial capacity often to do all that we understand to be required to address our issues and get our systems fully functional. With respect to administration, there are issues around case management. I think the Honourable Member for St. Joseph may have alluded to that, and we need to see improvement in case management. New judges alone will not take us there. As a matter of fact, this is the world in which the judges are forced to operate, and the effectiveness of their service is much dependent upon the efficiency of the administration, the administrative system around them, and we need to see improvement there again. That is essential if we're to get this matter right. I have heard repeatedly a lament expressed with respect to both investigative and prosecutorial effectiveness in Barbados. Those who often run afoul of the law and who have to face their day in courts sometimes, unfortunately, prove to be beneficiaries of lack of skills, again, perhaps which may be dependent upon lack of resources and lack of prosecutorial effectiveness in terms of the courts being able to probably mete out to one what one deserves in light of one's transgressions. So it's a question of effectiveness. It's a question of efficiencies. The technology platforms which we now want to see applied to in a wider frame to our practices here in this honorable chamber and into the daily operations of the executive arm of the government is also at issue with respect to the justice system. My understanding is that there's still some of the old archaic methods being used in the court system of Barbados, things like recording of evidence and all that type of stuff. We live in a very modern and fast-paced world. We have a growing economy, generally, notwithstanding the present circumstances. We have increasing levels of conflict among our populace, and we cannot afford to continue to have a court system that is stuck in an age which long we have passed, which is not adequate to respond to the circumstances now facing it. Because if justice cannot be administered clearly and speedily, in very many respects, it is in fact denied. So we need to get to a proper technological platform with respect to our court system. I think I've mentioned that in this House already. And the question will have to be asked and considered as to how we can improve the culture that obtains in the judicial sector or the justice sector in Barbados. There are those, it is my understanding, who feel that they must only be found to be at work for a certain number of hours per day, having attained the status of a judge in Barbados. There are those who take inordinately long periods of time to write up a decision, to render a decision. I think the Honourable Member for St. Joseph also alluded to that. So I'm simply trying to stress that it is clear that we understand it's not simply a matter of appointment of judges, but there are other issues which we have to address, constrained as we are. A diligent and determined effort must be made to confront those other matters. Now, I make reference, Mr. Speaker, to a report of the Caribbean Human Development Report from the UNDP. It's got 2012, which cites some of those issues that cause inefficiencies and lack of effectiveness in the system. Just want to refer to a few. One is the inability of the criminal justice system to process cases effectively and efficiently. That's case management, and in a wider frame, the whole issue of delays within the system. A lack of systemic data in relation to conviction rates. I think that is true, very much so here in Barbados. In Barbados, as far back as 2003, the National Task Force on Crime Prevention found that 48.8% of adjournments at the court were due to absenteeism by attorneys, not yourself, Mr. Speaker, witnesses, or even the accused. I know you bring, Mr. Speaker, very high level of discipline.
I remember speaking in 2003.
Yes,
2003.
2003. That relates to 2003. And then insufficient alternatives to incarceration and weak rehabilitative strategies. I think we are very much familiar with that in our system here. We see the level of repeat offenses and offenders with which we are confronted. Then the overall need to regulate official corruption, which this government has moved in the direction of addressing the matter of corruption in public circles or public sector. The need for preventative programs throughout the region to target disadvantaged youth. And all that report seems to be suggesting to me by citing those frames is that the justice system can be made to operate more effectively and achieve the aims that we seek to have achieved as a society if we, yes, appoint more judges, but if we do some of these other things, which, as I said earlier, perhaps our financial capacity often constrains us from doing. Now, the Honourable Attorney General did point out to us in the bill the intention of government to ensure that there's established a commercial court. One would want to support that wholeheartedly for the reasons which he suggested. If we wish to make Barbados a major business center, we have got to ensure that those who invest in that enterprise have access and efficient and speedy access to justice. He alluded to the fact that, Honourable Member alluded to the fact that often large sums which could otherwise be invested are tied up because a business entity may make reference to its potential liability and therefore not utilize funds which otherwise could viably profit our economy and our society. So we wish to establish Barbados as a major business jurisdiction. Got to do that. We want to see our indigenous private sector so platformed and facilitated that they can render a larger measure of investment to our economy. We laud the fact that we've now reduced corporate tax rates in Barbados, and because there is now some relief which has come to that sector, entities in that sector are expected to expand and invest. Well, if they're going to expand and invest, we've got to create the climate within which they can more comfortably do that, and part of that is ensuring that there is access to a court which can look at commercial matters and give speedy decisions with respect to that. But we're also hoping that there will be a substantial increase in international business in Barbados, and I don't want to say that this is even more vital because the issues facing the domestic corporate entities are equally as important as those which will face international business investors in Barbados. So whether we look at business which comes to us from abroad or which is identified here locally, we've got to make sure that the context in which they operate is such that the issues can be addressed in such a way as not to find them hamstrung in terms of their investment, Mr. Speaker. So there's greater speed potentially in accessing decisions, but also I would imagine that there will be some special or specific expertise brought to this court. People who perhaps are more schooled in dealing with commercial matters, several of which were identified by the Honourable Member for St. Joseph, which are outlined in the bill. So it's not only the speed, but the specialist knowledge and skills that can be perhaps brought to the commercial court by members of the judiciary who are perhaps more inclined to be focused in that way. Now, I will have to ask the question, though, as to exactly what drives the government in this direction, apart from the fact that we are faced with a backlog of cases, and the ratio of judges available to us in relation to the number of cases on backlog is highly undesirable. So one will be prompted to think, yes, well, we need to increase the number of judges. But the question would be, beyond that being the consideration which prompts this action, what other research, what other studies, what other analysis may have been done to bring government to the position where it believes that we have to increase the number of judges, or we have to increase it by 5, and we have to have a commercial court, etc., etc. What is the studied basis for that? What is the analytical basis for that? What research has been done to inform that decision, if any? And Mr. Speaker, decisions like this are usually based on those types of premises. And I would imagine that one is driven and is schooled, as disciplined and learned, as the Honourable Member for St. Joseph would have ensured that decisions such as this one was based upon factual research and studies and so forth and so on. Now, I have to touch on a point that will prove to be a sore point for some. But I can only be me, Mr. Speaker. I can't be anybody else. I can only be me. I can only be me. And it's the issue of the appointment of the Judicial Appointments Committee. It's referenced here in the bill. It is that committee that selects and interviews and so forth applicants for position of judges. Now, the Honourable Member for St. Joseph alluded to the fact that in the 1970s, this country was caught up in controversy around the whole business of the appointment of judges in Barbados, and a political administration at the time that so wanted to have things enshrined in law that appointments to the judiciary became the purview of the Prime Minister of the day. Even the church was up in arms on that, particularly so the church on St. Michael's Row, not St. Michael's Row, as led by he who then was the dean of St. Michael's Cathedral. And it is still very much felt today that one of the reasons why the administration of the day lost the privilege of government was because of that swirling controversy around its intentions to ensure that judicial appointments fell to the Prime Minister of the day, as led, yes, and the opposition was led by the opposition of the day, successfully so. And lamentably, since then, we have not had a situation where this process has been made truly independent, potentially of, or independent of potential political influence. I choose my words very carefully. And so we have before us today, Mr. Speaker, a committee which will be put in place to oversee the process of advertising and screening applicants for positions on the bench in Barbados. Now, that is being touted as being a move in the right direction if we want to ensure the appearance of independence of action relative to appointment of judges. And that is fine, Mr. Speaker, except when we get to the point that the members of the committee, as identified with the Honourable Member St. Joseph, are in fact appointed by the Prime Minister. And appointments can be revoked by the Prime Minister. So you have a situation where the committee can recommend to the Prime Minister who appointed that committee there identified successful candidates for positions on the benches. Prime Minister has the power of appointment and removal with respect to the committee. I submit, and I always insist this, I lay no charge against the incumbent Prime Minister, but we have not gone far from where we felt a wrong had to be addressed if we have not removed completely from potential political influence the appointment of judges, and this arrangement does not fully take us there. Now, the Honourable Member for St. Joseph made reference, in your absence, Mr. Speaker, to the Latimer House discourse. There are some principles which are acknowledged to be highly, highly significant with respect to these matters. The whole doctrine of separation of powers in a democratic context. We know we have the appearance of separation of powers in our system because, in fact, the executive sits in the legislature and dominates the legislature. The executive, through the Prime Minister, has power of appointment over the judiciary, and therefore the potential again for influence and the absence of total separation. That's the reality with which we have lived for a long time. Particularly so with the present configuration of this Parliament, that reality is heightened. But so the principle of the three branches of government, there's a principle of the relationship of the Parliament to the judiciary, there's the principle of the independence of the judiciary, and others. This is in the Latimer House principles. The Honourable Attorney General referred to the Latimer House discourse. So that is there, Mr. Speaker, and it is considered to be a highly important matter that to the extent that we are able to arrive at that point, we ought to have fully manifest independence attaching to judicial appointments. This particular piece of legislation, though headed in the right direction, does not get us there. My role, in part, in here is to make reference to those things, and I simply do that with all due regard and respect. If we don't get that right, the transparency that we seek, the openness of which we boast, can be nullified, negated. And I humbly and simply and with respect suggest that we still have some issues around the independence of judiciary in Barbados, because it is still by this frame subject potentially to political manipulation and interference. And I'm saying I support the appointment of the additional judges, but the whole administration of justice, the context in which the judges will serve, has to be addressed. And I understand that financially we are constrained, and therefore we have to take it bit by bit. I want to commend the hardworking Attorney General for bringing this and support fully the move to appoint the judges.
Honourable Member for Christchurch East.
Mr. Speaker, I raise to speak in support of the Supreme Court of Judicature Amendment Bill 2019. I would like to commend the Honourable Attorney General for his exceedingly thorough presentation of this bill in a way, sir, that anybody at all listening can have an appreciation of the factors which inform the preparation of the bill, the concerns that the government have, the concerns the Bar Association has, and the thought that went into where we are now. This is twice today, sir, that the Attorney General has spoken, and as he was speaking, I looked at almost every part of my notes that I had made for my presentation and started tick off. To the point where I appreciated the fact that he covered all the technical aspects, leaving me open to address some other ones that I otherwise would not have done. And I hear as well, sir, the comments of the Honourable Leader of the Opposition. And I wish to start by addressing some of the comments of the Honourable Leader of the Opposition. The Honourable Leader rightly said that the government does not have at present the financial resources to do all that we need to do. And I agree with that entirely, sir. Having said that, the Honourable Attorney General did indicate that this is step one, that we're going to come back to the Supreme Court of Judicature Act, and very likely further amendments are going to be made. There are a number of other concerns that I have, sir. I understand why it is necessary for us to debate this amendment now, as opposed to waiting for a holistic overhaul of the Supreme Court of Judicature Act. So I wish to assure the Honourable Leader of the Opposition that we don't have the resources to do everything we need to do now, but we are starting now with the ones that require the most urgent attention and are prioritizing the resources that we do have to get the ball rolling. Sir, the Honourable Leader of the Opposition also spoke to his concerns that the criminal justice system is in need of some management, some data, improved data, and it needs to operate a little bit more effectively. I agree entirely with the Honourable Leader of the Opposition in this respect. And it is one of the things that I hope that we are going to come to. As you well know, sir, from the bulk of your practice, the system is broken. It is broken. We desperately need judges, but there are also other things that we need to do in respect of the criminal justice system. And I wish to assure the Leader of the Opposition again that while everything that needs to be done with respect to the criminal justice system has not yet been done, a fantastic start is the allocation of 5 judges and 5 courts to help clear up that backlog. Because the most glaring thing is the backlog in the court system. Having said that, I agree with you. The records need to be made digital. But I understand that the government already has that in train. We're looking to digitize most of the information in the system. There's no good reason why the criminal record of somebody should be, the court should have to pause while somebody goes digging in a file alphabetically, bringing out a card or a series of cards stapled together in this day and age. I agree with the Leader of the Opposition. But sir, these are things that we know. And these are things that we're trying to address. So I wish to assure the Leader of the Opposition that while it is not necessarily addressed in an amendment here, this government is entirely aware and is working especially on the record-keeping aspect that you alluded to. Now, having said that, there's something else I wish to say. We could have all of the judges in the world. We could have all of the courts in the world. We could have the most effective digital record-keeping system in the world. We could have the best CAT transcribers in the world. But if our archaic approach to the justice system does not change, we're not going to get anywhere. We have made a start, but it requires an overhaul, a complete overhaul. Judges need to change the way they think. There's arisen something in our culture. Sir, I don't know where it comes from. I don't know whether it starts from University of West Indies. I don't know where it starts from schools, how we teach children. But we are so afraid to get it wrong that often we do nothing. We do nothing. We are paralyzed into inaction by our own fears. Children are afraid to get it wrong in class, that they don't exercise independent thought. Even in law, sir, the laws are created and jurisprudence evolves by people who challenge the status quo. They choose to interpret something differently than has ever been interpreted before. And that's how we get new laws. But when everybody is worried in school about getting it right, so you give back to the teacher what the teacher taught you, then we are getting nowhere. This translates all the way up. We have some timid lawyers in Barbados. We have lawyers who are not prepared to push the envelope. I know this does not apply to you, sir. I know it also does not apply to the Honourable Attorney General. But until the lawyers develop the confidence to challenge the status quo and challenge the judges and challenge the existing laws, we're not going to get anywhere. I use as a case in point, coming on to the last election, when the government was refusing to register the Commonwealth citizens, and this had happened over and over, and everybody was traipsing along with it. Some lawyers dared to challenge it. They dared to challenge it because it was a matter of national importance. And they dared to challenge it. It got knocked down. Sorry, it was supported first by the Chief Justice, sitting as an individual judge. It was then dismissed entirely out of hand by the Court of Appeal, at the time led by someone who is now ascended to the highest court in the land, only to go up to the CCJ and perhaps the record time for any case in Barbados to have the appeal entirely upheld. But that shows what happens, and that shows how our judicial system can work quickly if the lawyers are bold, the judges are not afraid to make a decision, the Court of Appeal is not afraid to make a decision quickly, and the CCJ is there to preside over it all. I use that as my intro to the point I'm prepared to make. Quite often, something has crept into our system in the simplest of cases. You sit down and you listen to two lawyers present a case in the court. It is obvious by the time the evidence has been led, how that case must go. Anybody listening with a modicum of common sense can see from the argument how the case must go. But yet we adjourn, or the judges adjourn to come back with a decision. And they proceed to take months to write a very well-written, very, very long decision.
I don't remember you saying months. Are you sure of that, sir? Months?
In the urgent cases, sir.
So,
in the average case, perhaps a couple of years. But they take forever to write the prettiest decision and come back with a judgment that anybody who heard the case as it was going on knew the court had no other option but to come. And as the Honourable Attorney General said, it's even worse in interlocutory matters. For those who don't understand what an interlocutory matter is, it is a matter that occurs for decision or occurs for judgment during a substantive case. So it does not decide the whole case. But very often, the court has to make a ruling to decide how the case progresses thereafter. So until the interlocutory matter is ruled upon, the case can't proceed. Very often, these are urgent matters. Urgent in the court system in Barbados has no meaning. Urgent applications do not come on urgently. When they are heard, they may be heard urgently, but the decision then takes forever. Why are we so afraid to get it wrong? When I started in practice, there was a magistrate called Carlisle Graves. Mr. Graves would hear the evidence from the police presenting the case. He would hear the lawyers defend the clients. And as the last person has finished speaking, he is giving his decision one time. You know at the end of your case on the same day, within 5 minutes, whether you're going home or you're going somewhere else. We have other magistrates or judicial officers, and I don't like to call names, but I'll call this name.
you ought not to, sir.
Not in a bad way, sir.
No, we still ought not to. I permitted you the first time, but
We have some judicial officers who are not afraid to make those decisions immediately. And we need to get back to that. The court is the one place in the world that makes allowances for mistakes. You may not have allowances for your mistakes as a student. You may not have allowances for your mistakes as a politician. You may not have allowances for your mistakes as a businessman. But the fact that the Court of Appeal exists suggests that the judges don't always get it right. The fact that the CCJ exists suggests that the Court of Appeal will not always get it right. But there are levels to step up to get a final decision. I don't know if it is something that we will eventually need to legislate, but I'm urging the powers that be that when this does pass, and that is not us, when this does pass, then the judges look not just at their full complement of 13, but they also need to look at the way the business is conducted in the court. Let us take another example, sir. When a man is arrested and charged for an offense for which bail cannot be given at the lower court, he should not be taken to the lower court for a magistrate to tell him, I don't have the jurisdiction to grant you bail, and then he goes back up to Dodds and then has to apply to come before the High Court for bail. He should go before a competent judicial officer to grant him bail on the first instance as of right. He should waste no time in the magistrate's court. If you are charged, for example, with a firearm offense, then let your first appearance be before a judicial officer who has the authority to decide on your bail hearing. That is another layer where time is wasted. When a man gets bail in the High Court and his surety is examined and the judge approves the surety, that man sometimes goes up to jail for months until the administrative process can be completed to grant him bail. Whereas if that same man came in front of the magistrate for effectively the same offense, and the magistrate granted him bail and approved his surety, he's going home immediately. These are anomalies within our system that we need to look at. So I take comfort in our Attorney General saying that we're coming back to this. I take comfort in it, sir. And for a reason. I have had dealings with the last Attorney General in my former life. Chalk and cheese. Chalk and cheese. I actually have a genuinely held belief that this Attorney General gives a damn. I have a genuinely held belief that this Attorney General, as a recognized, accredited, accomplished, practicing lawyer, that he has an interest in seeing that Barbados at the end of our term has the best option for judicial system that we have ever had, that things work. He grabbed the situation at the court by the scruff of its neck, and I see a lot of work proceeding. I'm going to be happy to attend when they reopen the court. We have amended significant pieces of legislation. This is an Attorney General that works. This is a cabinet that works. This is a government that works. To the Honourable Leader of the Opposition, you did say that a commercial court is necessary for Barbados to become a commercial hub, and I agree with you. And the reason that a commercial court is necessary is because quite often people just need to know where they stand. They just need to know yes or no. Because whatever the decision is, you can then take the steps to further your decision or to make your appeal. So for the commercial court is necessary, especially in business situations, because businessmen and investors need certainty. They need an answer. And we need to apply this to all of our licensing regimes, all of our application structures, because delay helps nobody in the commercial arena. This is also a reason why we need to advertise internationally. I commend the Attorney General again for having the boldness to decide that applications should be received from anywhere in the Commonwealth. Trinidad has done it, Jamaica has done it. Indeed, our own Caribbean Court of Justice receives application for anywhere in the Commonwealth. Now, I am proud of the Barbadian jurisprudence. I am proud of our Caribbean and West Indian jurisprudence. But equally, I accept there are new areas of law that we are venturing into that we are not experts in. We have not touched them. So we're, especially for example, in the commercial arena, we don't have a commercial court jurisprudence. So in the initial stages, it serves us better to get judges who are authorities, who are intellectuals, who are accredited in that area, who specialize in that area. Let us do it right the first time. So I am not afraid for us to receive applications from overseas. I welcome the application process because, as the Attorney General indicated, quite often we heard, by the way, that so-and-so just be appointed a judge, and we wonder, how the bad word, did that happen? What really informed that? Who knew who and who? Sorry, let me leave that right there. Who knew who? There are Barbadians who would welcome the opportunity to apply. But quite often you did not know that a judicial appointment was being considered until you heard that the appointment had been made. There's a particular friend of mine who's a well-known lawyer in Barbados who he wants nothing better than to sit as a judge. That is, he was skin cuffings up and down here. Actually, I'd probably be embarrassed the first day he's in court because he'd probably be laughing and crying or something. But the fact is, we have people who want to do it. So I welcome the advertisement that any eligible and qualified Barbadian can apply. I welcome the advertisements because we can pull and select from the widest possible pool. The Leader of Opposition asked what informed the decision for 13 judges. Why 13? And I will say this, O Leader of the Opposition. I have no fear that 13 is a reasonable number, because had I my way, and had the majority of the bar had their way, it would not be 13, it would probably be 20. So I don't know what informed the exact number of 13, except perhaps to increase it by 5. But I would like to give you this comfort from somebody who practiced in the courts, that 13 is not nearly enough. It's a start, but it is not well spending or any avenue for patronage. It is a number that we must use as a minimum to start to get the ball rolling. Mr. Speaker, I fully embrace the adoption of the Latimer House principles in Barbados for a good reason. 10 years ago, 11 years ago, I spoke at the Commonwealth Law Conference. I believe it was in India or Hong Kong. But I presented on the Latimer House principles. And I made that presentation shortly after the laws in Barbados were changed to allow for the appointment of the current Chief Justice. I had no difficulty with the Chief Justice and his qualifications. But as a practicing lawyer and the head of the bar at the time, my concern was, we always talk about the independence of the judiciary and the transparency of the process. How does it look that the law was changed to facilitate the appointment of one person? I spoke then that Barbados and the Caribbean needed to move to the point of fully adopting the Latimer House principles. I believe we signed on to the convention which informed it. So I am very glad, sir, to be a part of the government that has crystallized those principles aimed at securing the independence of the judiciary through a fair, transparent application process and an independent panel that would select and inform, advise the Prime Minister. The Leader of the Opposition has some concerns about the true independence of the panel. I would have those concerns perhaps if the criteria is not set out. I would not question the independence of a former CCJ judge. I would not necessarily question the independence of a former Chief Justice of Barbados. I would like to believe that a sitting judge or a former judge of the court in Barbados would have the best interests of Barbados at heart. I have no doubt that the president of the Barbados Bar Association, in selecting the representative to sit on that panel, has only the interests of the judicial system at heart. So while the appointments are apparently political, the fact is the caliber of persons and the criteria for appointment has embedded within it some security as to the independence of the process. If you look at where we are now, that one person can pick and choose the judges without reference to anybody else, then for us to go to a panel which advises that person, which advertises, selects, investigates, interviews, and then makes a recommendation, I think we have come a long way. Maybe we may look at it again, but we are a long way from where we were this time yesterday. The other thing that I wish to say, Mr. Speaker, is that specialized courts will necessarily yield or result in specialized judges. Specialized judges guarantee efficiency, but equally, I welcome the specialization of judges because we've had some judges in Barbados, and Mr. Speaker, you know them. The judges may be excellent in civil, but they don't have a human bone within their breast. I am thinking of one in particular who is very good to make impartial decisions, but you can mitigate on behalf of a youngster as much as you want. As much as you want. You might as well be blowing that smoke out of a moving car. But when you have judges who are versed in the field in which they are acting as judicial officers, then what happens is you have people generally who have come through the system. They know it from both ends. And they can properly lend a discretion or a judicial intervention, having had the benefit of practical experience. I do think it's a shame that the bulk of our judges have come through the public service, because we know we've had a prosecutorial slant to many of our judicial officers. Many of our judicial officers have made the transition from prosecutors to magistrates or judges. You don't throw off a jacket and put on another jacket and become a different person. So I appreciate entirely the fact that we're going for specialization. Specialization also renders it more efficient because the judge does not then have to go and do, they may have a grasp of things at their fingertips that they would not have had if they're not specialized in the area. In particular, I want to make this plug. We are having a family court, not a family division of the civil court, but we're looking to have a family court. In the area of family law in particular, I believe it is necessary to have specialized judges with specialized training. The family, there are few people in Barbados who have done more domestic violence cases than I have. And when you have a family situation, the same rules don't apply. Yes, on one side is the application of the law, but on the other side, the judge is a counselor, an advisor, a psychiatrist, a psychologist, and everything. And their aim in a family situation is a lot less about the right or wrong of it according to the law, as opposed to trying to make a decision that is fair to all concerned, bearing in mind the positions of the parties and the individuals that you are dealing with. So I am pleased that we're drifting towards specialized specialized courts, still in the cricket frame of mind. I am pleased that we're looking at specialized training for judges. I am pleased that the Attorney General has indicated that this is just a start. I am pleased that the Leader of the Opposition has raised questions, and I hope I have been able to provide some measure of comfort to him. But I look forward to the next stage. I look forward to us leaving our stamp on what is happening. Not our stamp in terms of a political influence, but our stamp in terms of our usual measure of success that we seem to be accomplishing now as a government. The last thing I wish to say, Mr. Speaker, and I left it for the last because I would like it to actually be heard. Sometimes the accused man gets off. The point I'm making with this is to get rid of our backlog. It is not just necessary to increase our judges. It is not just necessary to put more courts. But for our backlog to go, we can't get it done by solving and deciding all the cases. We also have to get it done by deciding which cases to let go. When the police arrest somebody, the police would have done investigations and there is a file. There is no reason having a file sufficient to charge a man, you don't have a file sufficient to start a case that years down the police are still waiting for the file to be completed so that the prosecution can start, especially in what I call victimless crimes. There's no reason that a man on a charge for a spliff or 2 spliffs should be waiting a year to have his case started. The police know as well when they have cases that they cannot win. They know in looking at the evidence that they cannot win the case. The complainant has come and said, I don't want to proceed. The main witness has died. People have written in, they've left the country, they're not coming back. But yet we come to court, sorry, I say we. Yet the lawyers go to court only to have the cases adjourned and adjourned and adjourned and adjourned and put back. The prosecution and the courts need to look honestly at the cases that have no chance of going anywhere and let those go. Let us start eliminating our backlog by letting go the cases that are not going anywhere. There's a particular case I'm thinking of. The man has been charged. He has begged the prosecution to start his case. It has been years. He's offered to represent himself. He has said, start the case. I have written over, and when a man is saying, just do the case, please, and you can't start that case in a couple of years, you might have to take an honest look at that case and make a decision. But sir, I am leaving here today feeling good. I am leaving here today feeling we are on the right track. I am leaving here today excited by the fact that we're going to have a full complement of judges and we can perhaps get things going again. I am leaving here today exceedingly happy with my Attorney General. I am just sorry that I am not on the other side now able to take advantage of what he is now putting at the disposal of the people of Barbados and judicial system. Well, I'm sorry in a way, but I'm glad to be here. So it's like a double-edged sword. But I just wish in summary to say that I entirely, wholeheartedly, with 100% of my being, support the amendments to the Supreme Court of Judicature, Bill 2019, and look forward to their passage and application as quickly as possible into the judicial landscape of Barbados. Mr. Speaker, I thank you.
Honourable Member for St. George South.
Thank you, Mr. Speaker. Mr. Speaker, I rise to join this debate, cognizant of the time. And, Mr. Speaker, I am coming after 2 legal luminaries, and indeed 2 others will follow after. And indeed, I'm happy to be in the center of these legal luminaries. But Mr. Speaker, I wish also to start by commending the Attorney General and member for St. Joseph for bringing this transformational piece of legislation, and indeed this bill before the House that seeks to amend the Supreme Court of Judicature Act, Cap 117A, to make provisions, Mr. Speaker, to increase the number of High Court judges, for the establishment of a Judicial Appointments Committee, and where, Mr. Speaker, I plan to spend the next 20 minutes, the establishment of a commercial court. And, Mr. Speaker, over the last 3 weeks in this honorable chamber, we spent time dealing with some serious transformational pieces of legislation. The Planning and Development Bill 2019, that was one. The Immigration Amendment Bill, that's two. And now today again, the amendment to the Supreme Court of Judicature Act. And what these three pieces of legislation speaks to, Mr. Speaker, is the ease of doing business. And when we look at the World Bank rating for this country in terms of the ease of doing business, we are ranked 129th out of 190 countries. And the courts, the efficiency of Barbados' legal system has a significant bearing on commerce in this country. And that is where I wish to spend my time this afternoon. So, Mr. Speaker, the pace at which commercial disputes are resolved can impact the growth of investment and indeed can impact economic development in this country. So in order for business to thrive, they require an environment where commercial disputes can be resolved quickly, affordably, and consistently. And the court, therefore, Mr. Speaker, plays a critical role in business facilitation in this country. And I wish to read from an IMF working paper. The name of this paper, Judicial System Reform in Italy, and it speaks to keys to growth. And it says, enhancing the efficiency of the judicial system can improve the business climate, foster innovation, attract foreign direct investment, and last but by no means least, secure tax revenues. And Mr. Speaker, the commercial courts generally hear and determine cases coming out of business transaction, or what we call commercial transactions. And these can include matters relating to intellectual property. I heard the member for St. Joseph, he spoke about bankruptcy and insolvency. I'll get there. But also the enforcement of contracts, Mr. Speaker. And this speaks to business, doing business in this country. And the court also preside over cases relating to imports and exports of goods. That, Mr. Speaker, is commerce. So I am pleased this afternoon, like the honourable member for Christchurch East, it warms my heart to know that the Ministry of Small Business, Entrepreneurship and Commerce has before this House a piece of legislation that will indeed augurs well for the businessmen in this country. Not only the large ones, but for the small ones, even though the commercial court will hear cases as it relates to large businesses. And it is always good to know that, because some people don't know, I know the members in here know that, the Ministry of Small Business, Entrepreneurship and Commerce has under its remit the Consumer Claims Tribunal, which hear matters for small businesses less than $10,000, 10,000 equal to or less than $10,000. So we have a system whereby we can listen to the average man, the steel bender, who brings a case against someone, mechanic or some person who owns a car who brings a case against a mechanic. So we can have speedily resolution. And indeed, it is working. And listening to the Attorney General and the member for Christchurch East during their presentations, one can rightfully say that indeed justice has been delayed in this country. And justice delayed means justice denied. And I will say from a business perspective, justice delayed means business denied in this country. So I am indeed happy that we can come this afternoon to debate this transformational piece of legislation to improve the ease of doing business. And I am positive that as we continue on our journey, looking at legislation that can impact business significantly, and that can, as the Prime Minister says, the member for St. Michael Northeast says, that can unlock economic development in this country, we indeed are happy and we are on our way to economic recovery. Now, one of the areas that I wish to speak on now to show the impact of this piece of legislation on business, and on page 8 of the bill, is the first schedule part 2, and the commercial court will look at a number of areas, and one of the areas that it will focus on would be bankruptcy and insolvency. And I wish to spend a few minutes there because the Bankruptcy and Insolvency Act came into being in 2001. And indeed, this act came into being with a view to sustain businesses and to restructure business operations, to prevent premature liquidation on businesses, and to ensure that the creditors don't indeed experience extreme losses when businesses go into insolvency. So that's the whole essence of the Bankruptcy Act back then that came into being, I think it was 2001. And why I'm going there, Mr. Speaker, because of the delay in the court system, we have had a number of businesses that were indeed crippled. And I'm going to go there because part of the Bankruptcy and Insolvency Act, one of the key features of this act, is the ability of the insolvent debtor to make a proposal to its creditors. And a proposal is essentially an offer by the debtor to compromise the amount of debt owed to the creditors in order to permit the debtor to continue his business and his or her business. And through the use of these proposals that put forward by the debtor, indeed a company has the ability to save its businesses and preserve jobs and give creditors the best return. So that act came about, was enacted to save businesses in this country. And how the court comes in here, after the debtor put forward the proposal to the creditors, part of the process requires the court to accept the proposal. And indeed, I will cite a number of cases, at least 2, during my brief presentation, where...
Are you up, Honourable Member, you up, you met them documents of this Honourable Court?
That's fine. Where justice delayed was justice denied. And, Mr. Speaker, the first case that I wish to cite, well, not case, the first insolvency matter that I wish to cite is with Grants Hotels. Grants Hotels Incorporated was incorporated under the Companies Act, Cap 308 of the laws of this country. And indeed, the company's principal lines of business is the management and operation of hotels. And in 2003, Mr. Speaker, Grants Hotels sought protection under the Bankruptcy and Insolvency Act. And indeed, the company made a proposal to the creditors, and the creditors accepted the proposal, and this proposal then went to the court. And this matter has been going on for over 15 years, Mr. Speaker. This grants matter has been going on for over 15 years, and has been plagued by constant adjournment by the court and numerous changes in the judges. So we weren't only seeing adjournment on top of adjournment, but we were seeing the changes of judges. And indeed, several lawsuits emerged as a result of persons, one of the beneficiary owners, saying that they needed back all of their monies. And indeed, that opened the door for people like Clico Holdings then. And indeed, what has happened also is that prior to 2003, Grants Hotel would have applied for, and they were granted tongue and country planning permission to execute a development, Harry Smith property in St. Philip. But as a result of the delays in the court, the constant adjournment, understand that this matter, that development, which would produce what? Investment, jobs as it relates to smaller business, the steel benders, itinerant vendors who will drive on the site to sell those workers who are on the construction site. We have these matters having to see a loss in revenue and a loss in investment in this country as a result of the delay in the court system in this country. But that's not all, Mr. Speaker. I will give you another example. Redjet. Redjet, Mr. Speaker, also filed for bankruptcy. And this company, Mr. Speaker, under Section 16 of the Bankruptcy and Insolvency Act, made a proposal to its creditors as well. The proposal was filed in the court for approval. And again, there was a series of adjournments. But Mr. Speaker, worse yet, in January 2014, one of the key directors, Mr. Burns, passed away. He died before the matter could be heard. And as a result, Mr. Speaker, in excess of 250 creditors and 94 employees, I repeat this, as a result of justice being delayed, 250 creditors and 94 employees associated with the Redjet case were unable to recover any of the debt owed to them by the company. So those are two cases, Mr. Speaker, where clearly you can see the impact on the issues in the court system, on commerce and on business in this country. And we spoke about 94 employees with Redjet, and I'm certain that the grants issue has tied up a lot of small businesses, or has denied a number of small businesses from benefiting from commerce, whether it's itinerant vendors, steel benders, people who are selling, the block manufacturers. So you see the impact the court system would have had on commerce in this country. And I wish now to quote from Justice Hayden, and I heard the Attorney General and member for St. Joseph mention Justice Hayden during his tenure as a student. Justice Hayden in the Australian Supreme Court case of Aon Risk Services Australia Limited versus Australian National University. And he aptly captured the importance of effective court systems to commerce. And I quote, he stated, "Commerce life depends on the timely and just payment of money. Prosperity depends on the velocity of its circulation. Those who claim to be entitled to money should know as soon as possible whether they will be paid. Those against whom the entitlement is asserted should know as soon as possible whether they will have to pay. And he went on to say, in each case, that is because it is important that both the claimants and those resisting claims are able to order their affairs, to look after their affairs. And he went on further to state how they order their affairs affects how their creditors, their debtors, their suppliers, their customers, their employees, and in the case of companies, their actual and potential shareholders order their affairs. And in closing, he said, the courts are thus an important aspect of institutional framework of commerce. The efficiency or inefficiency of the courts has a bearing on the health or sickness of commerce. So, in essence, you saw Justice Hayden in the Australian case, citing the importance of commerce, not only to the shareholders, but to suppliers, to employees, to everyone. It is a total hold-up as it relates to justice being delayed within the court system. And this is a case, this is a popular case. So, ongoing judicial delays, Mr. Speaker, and the current court backlog continue to undermine the efficacy of this process, and by extension, the Bankruptcy and Insolvency Act. And I am indeed happy, and I know the small businesses in this country, small, large, and medium-sized, micro, are indeed happy that this government is indeed engaging in amendments and indeed bringing forth legislation that will indeed augurs well for business in this country. And I want to end by saying that as we seek to become globally competitive, we must implement reforms to improve the way the country does business. And this is one such reform. The establishment of a specialized commercial court is indeed a step in the right direction to unlock investment and indeed to unlock economic development in this country. And I end by applauding again the Attorney General for bringing forward this transformative piece of legislation. And I will end by indeed complimenting further the Prime Minister and the member for St. Michael Northeast, who indeed charted the way back then with our manifesto pledges as it relates to doing business in this country. And I want to thank you again, Mr. Speaker, for giving me the opportunity to make this brief intervention. And with those words, Mr. Speaker, I'm obliged.
Honourable Member for St. Peter.
Thank you very much, Mr. Speaker. I hope I do not detain us too long this evening. Yes. But I just felt I needed to share a couple of thoughts, a few things on this bill, the Supreme Court of Judicature Act, bill, as it is at this point. Justice, Mr. Speaker, is or could be considered a fundamental tenet of any good society. You cannot have a good society without having justice in some form. And if we go back to biblical times, and the Honourable Member for St. Joseph was beginning to go where I would normally associate the Honourable Member for St. Michael West to be going, and waxing biblical, reflecting his roots and his connections. But, Mr. Speaker, from biblical times, there was the whole matter of justice. The Honourable Member spoke about judges in Scripture, and when he quoted the Latimer rules, one of the things mentioned had to do with gender. And I would just want to, I believe he knows, but maybe he would repeat it for him, that even in Scripture, there was a female judge. Deborah in scripture was a judge, so there was an attempt even in a very gender-biased society to include females in the roles of judges. Mr. Speaker, I want to focus a bit on the concept of justice, not just the traditional legal form of justice or the legal thinking that where people's minds go to as it relates to justice or when they hear discussions about justice. This party, whenever I say this party and I look at the Honourable Member for St. Michael West, I have to, because I keep, what is in my head, Mr. Speaker, is that the signature at the back of the manifesto that is closest to the signature of the leader of the party. That's his signature. I don't even want to say it. But in that document, we spoke about creating a social justice committee, and the social justice committee has to do with the fact that we recognize as a party and now as a government that justice must be available to all members, all segments of society, and it must be a justice that goes beyond the justice that is available in the courts of law where you are quite familiar. But I know, sir, Mr. Speaker, that you are also familiar with the other areas of social justice, having practiced as a social worker yourself. And so you would be familiar with the kind of justice that we're talking about when we speak more to social justice. Because, Mr. Speaker, if a society is to be comfortable and feel certain measures of equity among members of that society, then there has to be the availability of justice. It has to be there, it has to be available in all its forms. There has to be access to that justice, because it just can't be there, but there be hindrances to accessing the justice. And then the system of justice has to be effective. And many speakers before me would have spoken to the time that it takes to have cases heard. There's a certain effectiveness that attends to justice and the feeling that there is justice. Because justice often, Mr. Speaker, has to do with a person believing that they have access to justice and that justice has been served. And I want to say that as the member responsible and the minister responsible for social partnership and also the Social Justice Committee, that civil society will hold the judiciary accountable. And I'll get back to that in a little bit, but civil society will hold the judiciary accountable. The Honourable Member for Christchurch East, I think it was, said, and I agree with him, our system of justice is, in my view, broken. It is a broken system. There's a backlog in the court system that has become legendary. But I also want to say and to admit, like I did a week or two ago, well, a couple of weeks ago, that even in my ministry, with the Employment Rights Tribunal, there is a backlog of cases that is also legendary. If we look at the National Insurance Department, the tribunals in that department, severance payments tribunals, have a backlog. And it seems as though in every aspect in every space where there's expected to be justice dispensed, there is a backlog. And that supports my view that the system is broken. The one who preceded me in representing the constituency I now represent is known for a statement that he often made and still makes: face it and fix it. And I'm happy to be part of a government and part of a party that takes that seriously. And so even though we admit that even in our tenure, there are backlogs, there is a certain dysfunction in some of the systems set up to dispense justice, we understand that as persons elected to lead in this country, we have to face the issues, we have to face the problems, and we have to fix those problems. And that is what this bill is all about: facing it and starting the process of fixing it. There are consequences when a judicial system or a system of justice is broken, when it is malfunctioning. There are consequences. The Honourable Member for St. George South spoke to justice delayed being justice denied. And we have to remember that this justice is, in many cases, about people. And when we deny justice to people, we're not being good leaders. We're not being a good society when the people in our society believe that they are not being served well by the justice system. And so it affects people, it frustrates them. They begin to feel alienated. They begin to feel that they have no recourse. I want to say that every Wednesday I have clinic in my constituency, and there are persons who come asking about jobs. There are persons who come asking about housing. Maybe those are the two most frequently discussed topics. But I want to say to you, Mr. Speaker, that the issue that my constituents raise that causes them the most angst, that frustrates them most, is when they're dealing with either attorneys at law or the law courts, and believe that they're being messed around, that they're being tossed to and fro, that lawyers are not getting back to them, that they are not being able, they're not in a position to receive from the justice system that which they believe every citizen of this country should be able to get from the justice system. That, Mr. Speaker, I believe frustrates them more than anything else. They sometimes begin to feel oppressed in their own country. They begin to feel like second-class citizens in their own country. They sometimes get to the point where they believe that justice is being perverted or that there is no justice in the society. And I want to say to this honorable chamber and to Barbadians that when people start to believe that they have no recourse to traditional justice, it may occur to them that they may have to work out their own way of getting redress. And that is a place where a society does not want to go. That is where we advise our constituents that you cannot go. But Mr. Speaker, if they can't go there, then they must have recourse to a system that works. And a system that works to dispense justice, not necessarily in their favor, but that dispenses justice fairly for them and for their families, for their relations, for whoever it is that they are really, that they want justice for. The Honourable Member for St. George South also spoke to the matter of, he spoke more to the business aspect of this Act, how it will affect business. And I want to support him in saying that one of the considerations that an investor takes into mind when considering where to set up business is how disputes are going to be settled. That is critical. So you can offer all kinds of inducements, you can offer all kinds of concessions, you can give away the land for free, you can do all kinds of stuff, but if his or her business, or if the company's business is going to be hamstrung because a case that should normally take 6 months or a year ends up taking 7 years or 10 years or 12 years, if that becomes understood, then business people think twice about investing in such a country. And so they should, because as business people will say, time is money. And to wrap up a business in all kinds of legal cobwebs puts the business also at risk. In a former life, I was an auditor, an accountant. And if you have a case hanging over you, which has the potential to cause you to create some kind of liability, then on your balance sheet, you have, under the International Financial Reporting Standards, to report the contingency. And that affects your share price, it affects the value of your business, it affects how people see your business operation. And so these are matters that businesses cannot necessarily get away from, but they need to be resolved speedily. They affect not just the business, but Mr. Speaker, I always say, and I want to keep saying, when a business that employs people is compromised, then those who work for that organization, their livelihoods are also compromised. When businesses refuse to invest, or investors refuse to invest, then those are potential jobs for people who live in St. Peter and other places to get that they may not necessarily get. Those things also affect our position in the Doing Business Index, because some of the measures that are used to determine where you sit or stand or lie in the index relate to how speedily matters at law are resolved. And so Barbados business people are impacted when we don't get the judicial system right. When we don't get it right, it also affects family relationships. Children in custody situations, maintenance situations, people are impacted when the judicial system does not operate in an effective manner. Justice for those who are victims of criminal activity is also impacted when there is an ineffective or inefficient system of justice. And Mr. Speaker, I want that Barbados and Barbadians understand that the judicial system, the system of justice, and the way we dispense justice must be improved. Now, I hold, it appears, a slightly different view from the Honourable Leader of the Opposition as it relates to how far-reaching this bill should have gone. To use an analogy that the Honourable Member for St. Michael West will be familiar with, I want to say to him and to the House that Adam and Eve were created as adults, fully grown, ready to act, to work, to procreate, etc. Everybody else after that had to creep before they could walk, before they could run. And so I have no issue with this bill not being a perfect bill, or a bill that does not get us to the place where the honourable member was referring to, because I believe that we are not in a position to wait for perfection before we bring a bill to this House. We can address the issues incrementally. And the Labour Party, the party that the honourable member was a member of, and we are a party, I would not say in terms of historical analysis, a gradualist party, but we have been a party that has no problem in creeping before we walked. So for example, when we are criticized for our position on education, this party decided to test before we went the full way. We established some schools to provide free education because we understand that nature dictates that you creep before you walk. We know what happened in Jamaica when former Prime Minister Manley decided to come out of the egg and run. You can collapse an economy, you can collapse a society if sometimes you are not taking the steps to get to where you want to get. And so, Mr. Speaker, I have no challenge in taking this first step of increasing the number of judges who will hear cases at the level of the High Court. And I believe that it is an excellent move on the part of the Learned Attorney General, the Prime Minister, and this government. The establishment of the four courts, I think will come to be realized as a masterstroke. The Honourable Member for Christchurch East spoke to specialization. And Mr. Speaker, I want to say to you that there is no reason why physicians are able to specialize in cardiology, hematology, dealing with the head and the brain, ear, nose, and throat, dealing with diabetes. There's no reason why physicians should be able to specialize. There's no reason why in the accounting profession, people specialize. In economics, people specialize. There are labor economists, there are macroeconomists, there are all kinds. There's no reason why this should not happen in our legal system. And I agree that with specialization comes the development of the skills that make for efficiency, because the thinking, the knowledge is built up. You, Mr. Speaker, are known for a particular type of law. And if I know anybody in my constituency who is in a challenge where I believe you could help, I will give them your telephone number. If, on the other hand, there was a matter, with big business and a lot of rich people, I may not come to you. You are a little bit too grassroots.
That's why you remain poor and humble, you see?
Yes.
Right, that's why you remain poor and humble, because they represent the oppressed.
Right, you deal with the oppressed. And there are others who specialize in doing conveyancing and doing other things. And so then there is no reason why we should not have these divisions of the High Court. The civil division, which will deal with, lawsuits, torts, where people have issues, people being disadvantaged. You have criminal division, murder, burglary, those kinds of activities. The commercial division, the Honourable Member, the Minister for Commerce spoke to that, contracts, insolvencies, issues of intellectual property, which will become important, especially with the Honourable Member for St. Philip West driving the creative economy. And then the family division, children, maintenance, matters, etc. Those divisions, and creating persons, judges, who will begin to specialize and really get on top of their game in these different divisions, in my view, Mr. Speaker, is a big step in the right direction. Now, the judicial Appointments Committee is the next I want to speak about. The last thing, because I promise not to detain the chamber too long. I want to run the risk of breaching the standing order.
What would you want to do, Honourable Member?
I want to reinforce what a number of speakers before me have said. I know there's a standing order that speaks to repetition.
I see.
But I think it is important to point out that the second schedule is, it speaks to the way, to the ethos of this party. The broadening of, almost the democratizing of activities that were once the purview of individuals or very narrow groups. People will be people. And so to create the view in either the minds of the members of the chamber or those on the outside that there is some method that will not be subject to any kind of bias is really to say that we have all gone to heaven, and so we really should not be in here. Every human being will have some kind, but I don't necessarily believe you have to die first, because I am convinced that Enoch did not die. But maybe we'll have to ask the Honourable Member for St. Michael West to coach the Honourable Member who made the error a little bit. It is, in my view, important, Mr. Speaker, that we democratize some of the methods that we have, especially in situations where we are selecting judges in that third arm of our system. And I believe, Mr. Speaker, that a committee that includes those included in the second schedule, the Chief Justice ex officio, one person who's a former justice, one person who's a former Chief Justice or a former Justice of Appeal, a former judge of the High Court, a member of civil society, and an attorney at law with at least 10 years standing who is a member of the Bar Association. Now, Mr. Speaker, 6 persons with these kinds of credentials, in my view, constitute an excellent committee. And I want to applaud the learned Attorney General and the Prime Minister and all those responsible for crafting this, for including a committee such as this. And I want to go further to highlight that member of civil society. I said earlier that civil society will be holding the judiciary accountable. And I believe that it is demonstrative of the stand that this government, this party has taken with respect to engaging those in our society, that we would think to include a member of civil society on a panel, on a committee that will be responsible for selecting judges in this country. I think, Mr. Speaker, it is a move that ought to be applauded. It demonstrates that we have confidence in our people. We have confidence not just in judges and people who have been practicing for 10 years or who have been chief justices. We have confidence in civil society. And so we have included in this committee a member of civil society. And I want to, as I commend this to the country, I want to say to the country that this is but one measure of our commitment, one step, one demonstration of our commitment to include civil society in the governance structures of this country. No longer will the view go forth from this place that only 30 persons in here can be responsible for leading the country. We are leading a country of thinking, educated people. We are leading a country of persons who are vested in the development of the country, and we will include representatives from those groups in the governance of this country. That is why we set up the Social Justice Committee. The Social Justice Committee is made up of persons from the Youth Development Council, the Men's Association, the Women's Association, the Parent Teachers Association, unions, business, employers. All sectors of society must be engaged in the dialogue on the development of the country. All members of our society must be represented at the levels where decisions are going to be made on the justice system and how it functions in this country. And so I want to commend the entire bill, but that particular inclusion, I really want to commend that to the people of this country. Our approach speaks to transparency, accountability. It speaks to democratization. It also speaks to the non-encroachment. There's been a lot of references to the Latimer principles, but this committee, this Judicial Appointments Committee, speaks to a significant attempt to hold to that separation between the legislature, the executive, and the judiciary. And I want to commend this. There is no perfect system on earth, I don't believe, at least not at this point. And I believe that this committee is a significant step in upholding those principles, those Latimer House rules, those Latimer House principles that speak to the separation. This committee speaks to that separation. I want to end, Mr. Speaker, just by two quotes. Martin Luther King said that we will not be satisfied until justice rolls down like water and righteousness like a mighty stream. And I think he was echoing a verse from Isaiah 56, which says, "Thus saith the Lord, keep ye judgment, and do justice, for my salvation is near to come, and my righteousness to be revealed." And with those remarks, Mr. Speaker, I commend this bill to this honourable chamber. I'm obliged to you, Mr. Speaker.
Honourable Member for St. James North.
Thank you, Mr. Speaker. You know, sir, as we near the end of a day, we have seen a government at its best at work in the interest of the people who elected us to serve in this position. We began the day with reforming the standing orders to give more transparency and accountability by members, especially cabinet members, to the people of Barbados. We conclude the day, sir, by improving the justice system, sir. One of the three elements of the arms of any government, and by improving it again for the benefit of the people of this country. On the first point, sir, an increase of 5 judges, moving it from 8 to 13, sir. As you know, as an eminent criminal lawyer, will benefit the process of justice, the administration of justice, and the delivery of justice in this country. so important and so fundamental. We have, of course, by our Constitution as founded in 1966, protected the independence of the judiciary. It is not like us, politicians, the legislative arm, that are, of course, we subject to scrutiny all the time, cussing, Facebook, whatever, sir. I certainly don't bother with that, sir. That comes with the territory, sir. That is what I signed on to when I decided to go into elective politics, as I always wanted to do from the time I was a teenager. But we have protected judges by our Constitution. We've maintained their independence. They get, within the context of Barbados, I think, handsome salaries, very good terms of office, top of the line, luxury car, allowances. Their salary, well, their salary can be cut after the amendment made by the last Barbados Labour Party government, but it could never have been cut anyway. So therefore, when the administration of the Democratic Labour Party in 1991-92 cut public servant salary by 8%, sir, they could not touch judges. They couldn't touch the judge's salary, the head of state salary, the DPPs, and the Auditor General's too, I believe, sir. And you know what that government did, sir? That government actually wrote to the judges asking if they consent for their salary to be cut 8%. And the judges, sir, in their wisdom, and I commended them, told the then government, no. We are an independent body. Part of that independence is sanctity of our salary and our terms and conditions, and they cannot be adversely affected, and we are not agreeing to the 8% cut, sir. That is the power of the office of a judge, sir. But to whom much is given, much is expected, sir. And look, it is true, we concede that there has been an increase in cases over the years. Sir, you would know, yes, the increase in criminal cases coming before the High Court over the last 7 years, sir, is great. There have been still maintenance of parity in terms of civil cases, but the fact of the matter is that most people want their day in court, and the institution of conciliation and negotiation, arbitration, in other words, alternative dispute settlement, is still in its evolutionary stage in Barbados. Is not yet fully developed, and therefore, while a lot of people will be better off not going in the courts, I think the Right Excellent Errol Barra, in fact, advised black people that they should stay out of Coleridge Street, sir. That is the truth. So while a lot of people would be better off trying to resolve their civil matters between themselves and the attorneys at law rather than going to court, the fact of the matter is that a lot of people feel, let me have my day in court. And the reality, sir, is yes, as the Honourable Attorney General has said, that we have some judges that take 4, 5, 6 years to give a decision, sir. To whom much is given, much is expected. Not every judge, sir, let me be very clear here, sir. But there are some that take too long, excessively long, to give a decision. And if you can't give a decision as a judge, sir, you should not be a judge. That is the frank reality. You should resign. You took the wrong career path. In my submission, sir, after practicing law 32 years before I came into the position in which I am in, most most cases a decision can be given in most cases the same time it comes before the court, as the Honourable, the same time that the evidence is concluded and submissions have been made. As the Honourable Member for Christchurch East, former President of the Bar Association, and well experienced in this area, sir, said, as a case evolves, sir, a good, intelligent judge should be able to say, look, the evidence, on the basis of the evidence, I can rule this way, in this manner, in favor of this party. And in fact, the best time to give a decision is when the case just concludes, when it is fresh in your minds. You have examined the witnesses, you have seen their body language, you have looked in their eyes and been able to determine their credibility. But as 2, 3, 4, 5, 6 years goes on and the case continuously fades in your memory, sir, it becomes more and more difficult to give a judgment. That is the reality of the situation. As the Honourable Attorney General said, the judges have signed on to a code of conduct that was brought, I believe, by a former Honourable Attorney General of this chambers, of this government, or of a previous government, sir, who went on to become Chief Justice of Barbados, sir. Eminent attorney at law, one of the best legal minds ever in the Caribbean, sir, produced a code of conduct whereby judges should give a decision within 6 months in any matter, civil matter. This cabinet, sir, has agreed, and the law will be passed, I believe it's presently being drafted, that we will amend the Constitution to create a judicial time period, sir, within 6 months to give a decision, sir. It's not fair to people before a court, whether Barbadians, non-Barbadians, whatever kind of case, that they have to wait so long for a decision, their life going forward, but they can't go forward because invariably a case which is so fundamental to the future determination of their life, a judge can't give a decision. When they've been given all the submissions and when they're in a position with all the research that you have, with all the technology that they've been given, and they can't give a decision. So it's not right, sir. We are trying to help here now by increasing the number of high court judges by what, 62%, from 8 to 13. And we're doing our part, sir, but we just have to call on the judges, sir. Not for us, you know, but for our constituents, for litigants that may reside overseas but have obviously business interests and matters in Barbados to resolve. So I am in absolute and full agreement with the establishment of a judicial appointments committee to make recommendations to the Honourable Prime Minister for judicial appointments. And the Honourable Leader of the Opposition made mention of the history of this process, whereby, yes, in 1974, between 1966 and 1974, our independence constitution had established a Judicial and Legal Service Commission. It was true, yes, appointed by the Prime Minister. That is true. So it was not fully clothed with political independence, because the commission was appointed by the Prime Minister, but yes, they were the ones who made recommendations on appointment then by the Governor General for judges. I believe that the Prime Minister, still under the Constitution pre-74, reserved the right to appoint the Chief Justice, and that was changed in 1974. And yes, the Honourable Leader of the Opposition is correct it was hell and fury around here, from the church right down civil society, on this constitutional change, and it's generally accepted as the start of the demise of the then Errol Barrow government, culminating in victory for the Barbados Labour Party in September the 6th, 1976. So yes, appointment of judges is a matter of public concern, and we are here seeking to address that in some way with the Judicial Appointments Committee. And that committee, sir, as has been named by the Honourable Attorney General and spoken about by the Honourable Member for St. Peter, is well composed, I mean experienced, people of integrity, former judicial officers, members of civil society, representative of the bar, sir, and we have full confidence that a committee so composed will give its best judgment in terms of recommendation to the Honourable Prime Minister. And sir, it is also important to note that the amendment here that we're debating to the Supreme Court of Judicature Act provides that the committee has to produce a report to the Honourable Prime Minister within 3 months of the end of the calendar year, a report on its business for the previous calendar year, and that report has to be laid in this Parliament, sir. In other words, public scrutiny of the work of the Judicial Appointments Committee. And we will do that, sir, because as you have seen over these last 8 months, we're about transparency, accountability, past financial, Public Finance and Management Act, all of this, sir, in terms of more efficient and effective and transparent governance of this country. And I totally commend that provision as well, that the workings and business of this committee will be laid before this Parliament after being presented to the Prime Minister within 3 months of the end of a calendar year. The advertising of vacancies in the judiciary is again absolutely visionary, sir. Commend the Honourable Prime Minister and Attorney General for including that in this amendment. I mean, as has been said, sir, in this debate, and as you well know, you wake up one morning, turn on the radio, 7:30 news, or look in the paper, and XY appointed a judge. Where you didn't even know that they had a vacancy or that you could have applied for this judgeship, sir. I mean, one of the highest posts in the land, sir, public post, paid for by the taxpayers. And you had that lack of transparency and you know, and everybody felt that that was right. The previous government that appointed, previous Prime Minister that appointed a few judges didn't feel that that should be changed, even though within his own party, sir, he was criticized over the issue. So we're not only going to advertise, sir, or the government will not only advertise within CARICOM, sir, but within the whole of the Commonwealth. In other words, jurisdictions with similar legal background and history, common law principles, sir, etc., to ours, judges trained in those countries, in those jurisdictions, will be able to apply to become a judge in Barbados. And that is right, because it was ironic that in our highest court, the highest court of this land, sir, the Caribbean Court of Justice, as the Honourable Attorney General said, judicial appointments for that court are applied for throughout the Commonwealth. And judges have actually been appointed in other Commonwealth jurisdictions, and you have a judge, as the Honourable Attorney General said, with a Dutch background, because of course Suriname is part of the Netherlands is of course part of CARICOM for the purpose of the original jurisdiction of the court, sir. And therefore, why then shouldn't we also, at our lower courts, sir, have that kind of provision whereby we advertise throughout the Caribbean and the Commonwealth to try to get the best that is available, sir. We have had judges, magistrates from other Caribbean countries, sir, that have been outstanding, sir. Up to a few years ago, I mean, sir, you practice in the magistrates' courts too, you would know. I mean, he's dead, sir, and calling his name in a good way, Magistrate Perry, sir. Traffic magistrate. I mean, legendary in this country from Guyana. So, you know, our judiciary and our judicial constraint, our judicial progress and case law and court formulations, sir, will be improved in this manner, sir. And we will know that we have the best that is available in the Commonwealth. I mean, the process of advertising is set out in the Act as well in 7.1, I believe, sir. Advertising the official gazette and in the newspapers and the media too, I believe, sir. In other words, there's a process by which you will get as wide publicity that there's a vacancy in the judiciary which is being applied for as possible. Instrument in writing to the Bar Association, and as I said, such other electronic means as the committee determines, which will ensure wide circulation to suitable applicants across the Commonwealth, sir. The amendment to establish and constitute specialized courts, sir, is long in coming. I mean, for years, attorneys who are specialists in family law have been calling for a separate family law court, sir. I mean, the reality, let's face it, sir, I mean, we haven't come in here, sir, because we are ignorant, sir. We know that you might be an attorney at law, but, I mean, when they used to have judges just from the public bar, let's say someone who was a prosecutor all their life, and they become a judge and they're not familiar with family law or with certain aspects of commercial law, bankruptcy, intellectual property, and of course they are growing areas now as the world develops and gets smaller, and those judges who may have been prosecutors may have been at bay when dealing with a case of intricate commercial matters or family matters, and therefore the move to provide for specialized courts, specialized criminal, civil, family, commercial, is commendable, sir. The Honourable Member for St. George South spoke in terms of the commercial court, sir. His ministry, of course, being Ministry of Commerce. And this is the way to go, sir. Again, something that ought to have been done long time ago. We, sir, commend this. We look forward to an improved judiciary, as has been said by all the contributors to this debate. This may not be the ultimate legislative amendments to make the judicial system and the administration of justice in Barbados perfect, sir. There's never seen a perfect piece of legislation yet. That is why you come and amend legislation in the future as you see defects. But for now, sir, this is what we are doing. This will mark some improvements in the system, sir. We call on everyone to cooperate, sir, not only the judges in terms of giving their decisions in a more timely manner, but attorneys at law, sir, have to understand that they can't be coming in court when the morning comes and asking for an adjournment, sir. They have to be prepared. Well, it's unprofessional. And the judges have to understand, sir, that you can't accommodate lawyer X or Y with an adjournment, sir, because I don't know, for whatever reason, I mean, there's a cadet society, as has been said in many cases, because they went to school with you, or I mean, the judges as well have to get strict with attorneys at law. This doesn't happen in other jurisdictions, sir. The Organization of Eastern Caribbean States have a beautiful, sir, judicial system, sir, on many matters, in many ways in advance of ours, sir. That is the truth. And it doesn't happen there. A case set, you come prepared tomorrow morning to do the case. No adjournment. And all of that causes delay. Sometimes people come in to Barbados from overseas and can't get the case heard. But time is money. And you know, the Honourable Member for St. George South spoke about ease of doing business, because that is one of the major mantra of this government. We have to become more competitive. We can't be at 129 in the world, sir, in terms of ease of doing business. And when the last Barbados Labour Party government left office in 2008, we were at 72. Decline. In fact, when in May last year, we were at 133. Declined 60 places in 10 years under the last Democratic Labour Party government. And they were happy about that, sir. The time it takes to do business is money, sir. All of this depends on and has a bearing on our gross domestic product, on our economy and our economic and social development. And we have to cut down on time spent in court by litigants. Can't be there for a 9 o'clock case, a judge come at 10 o'clock, and at 1 o'clock the case not heard. You hear the judge go on to lunch, and then come back, and you there at 3 o'clock, and the case not heard, and then the court adjourns, sir. Full day gone. Money wasted. Time. And Barbados not developing economically. So all of this, sir, is part of our trend to do business more efficiently, to become more competitive in this country, and that is why we brought, led by, of course, the efforts of the Honourable Member for St. Michael, South Central, the Town Planning Reform Act last month, sir, and that is why we're doing all that we're doing. We have, of course, been hampered, sir, by a judicial complex built not that long ago, but not maintained by the last administration, sir. And this time last year, breaks down, closed now, you know, last government doing nothing about it. And so, I mean, if you don't maintain your house, your car, whatever, it can break down. And a government that didn't maintain a judicial center that is relatively new. We've been hampered by that, sir. We've tried our best, led by the efforts of the Attorney General, and we hope to get that center back up within the near future. I know that whenever you pass there now, you see people working assiduously on it. And, you know, because of obviously accommodation for judges and for persons who go before the courts is of paramount importance as well. So this is the first step in our attempts to improve the administration of justice in this country. which is so important to the livelihood of many persons in this country. Is one of the arms of government, and all the stakeholders have to play their part in terms of the evolution of this system, sir. And this debate has shown the seriousness that this government takes on this particular issue. We've had contributions both from senior attorneys at law, sir, but also by others who are not attorneys at law but have tremendous experience in their fields, sir, and have been able to bring their viewpoint from that of laypersons in terms of the law, but experienced in their respective fields to this debate, sir. And we trust that all will play their part in trying to improve an aspect of our society and hence our economy that is so important. I'm obliged to you, sir.
Honourable member for
Mr. Speaker,
St. Joseph.
I'm grateful for all of the contributions to this debate. Perhaps it would have been a wonderful thing to have started much earlier in the day and benefited from the enthusiastic support, I hope, of all of the other members of the chamber. Many of them have indicated that they too would have liked to have spoken in support of this bill. I only wish to make a few further comments. The Leader of the Opposition is unnecessarily concerned, I believe, about the fact that the committee is going to be appointed by the Prime Minister. It has to be appointed by somebody, sir. Has to be.
Can't appoint yourself.
No, we could go to a plebiscite and have an election to set up a committee to determine who should set up the committee. And we could all cast our vote, and we can engage in all kinds of exercises. But I have a feeling that even if we did that, somebody would criticize the fact that somewhere at the apex of the decision-making power is a politician. I have faith in what we're doing, and I have faith in the people who have been elected by Barbados and Barbadians to serve. I have no difficulty with the Prime Minister at all nominating the committee. I find it unnecessarily, well, let me be kind, sir. Perhaps it is unnecessary to doubt the bona fides of a committee that is made up of a Chief Justice that certainly this administration did not appoint, a committee that would be represented in its makeup by a former judge of the Caribbean Court of Justice and other judicial officers. We can doubt everything about this process, sir, but it had to be appointed by somebody. What is more important is the nature of the individual that is appointed. And I believe that you can't, on the one hand, have individuals who have served in the highest judicial office of the land and serve with distinction, and then turn around and say that you're worried that they might be politically influenced. The other one thing I want to mention, sir, is that a number of other initiatives are being put on the table to try to improve the delivery of justice. While I did not go into details, I did mention that we were moving to the point where a lot of what happens in the court system would be electronic. And so we are moving very quickly, a little slower than I had hoped, but these are things that happen, sir. We're still moving quickly towards electronic filing of documents and electronic case management of documents. A lot of the technology has already been installed in the court. We just need to use it. There's software and other programs that are available, sir, that we're going to be put into place. The court is already, and I should say this publicly now, the court is very far advanced, the White Park Road complex is very far advanced in its refurbishment process, and I am assured that our deadline for the delivery of the fully refurbished building to the registry will be the last day of February. And immediately thereafter, the court will be beginning the process of moving back down to White Park Road. I had a meeting with the registrar today, and I told her that I felt that we could do the moving process without having to close the courts for more than 1 or 2 days. I'm aware, sir, that it is being said that the courts are going to be closed for 2 weeks to facilitate moving. Sir, the judges don't have to move anything. Their legal assistants don't have to move anything. And I believe that court, yes, there's going to be a day when you have to stop what you're doing and move. That's a fact. But we don't need to shut any court for any 2 weeks or even a week to be able to accomplish this. Yes, the moving will take a long time, but I'm fully expecting that there'll be a continued delivery of justice to Barbadians at the Warrens Complex until the day when the court reopens at White Park Road. And that day, I say to Barbadians, is expected to be the last day of March. I don't want to say the first day of April, sir. So on the last day of March, I fully expect that the courts will reopen at White Park Road. The journey ahead is going to be challenging. There are new things that have to be done, and people are going to have to expect new ways of working. Already the registry is working with less staff than they had 3 or 4 months ago. But we expect that we'll be introducing technology to improve many of those processes so that the burden on the staff will not be so great. Mr. Speaker, I'm asking Barbadians to have faith in our decisions. We, in our manifesto, promised the commercial court, and we are delivering it. But it is more than a manifesto or promise. The Honourable Leader of the Opposition wanted to know what informed the decision, whether any studies and analysis was done. You know, when there was an Ebola outbreak, sir, in Africa, we set up an Ebola clinic, an Ebola center on the premises of the QEH hospital. There was no study done to tell us that we needed to take preemptive measures just in case some traveler happened to cross the Atlantic, sir. When there's an outbreak in SARS, we don't run and do a study. We take preemptive measures, sir. That is what governing is about. We know that the judicial system is under stress, and we know that people are not being well served when it comes to the delivery of justice, sir. I will not be interested in another study so that 18 months down the line we've spent money on all kinds of specialists and experts to tell us today that we need more judges on our bench. I'm sorry, Leader of the Opposition, but that's how I see it, and I'm happy that my colleagues are with me. And with those words, sir, I beg to move that this bill be read.
This bill,
The amendments? We've pulled, there's a replacement bill. There are 1 or 2 typos, so we've replaced. Yes, so I beg to move that this bill then be read a second time, sir.
Question is that this bill be read a second time. All those honourable members in favor, please say aye. Aye. Those against, please say no.
Going to
think the ayes have it.
Yeah, I can do that. Mr. Speaker, given that there were 1 or 2 typos, the Honourable member who spoke immediately before me, St. James North, did say that there's no perfect piece of legislation. There were a few typographical errors. They have been corrected by the Chief Parliamentary Counsel's office, and therefore I wish to formally withdraw the bill which was tabled this morning and replace it with the new bill which has been circulated.
Question is that the earlier bill be withdrawn and the most recent bill be now circulated, that is circulated. Right. Be the bill. All those honourable members in favor, please say aye.
Aye.
Those against, please say no. You think the ayes have it.
Committee? Oh, sorry. Mr. Speaker, I beg to move that this House do now resolve itself into committee for further consideration of the bill.
Question is that the Speaker now leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favour, please say aye. Aye. Those against, please say no. Me think the ayes have it.
This House is now in committee.
Clause 1.
Mr. Madam Chairman of Committees, I beg to move that what I'm sure was said to be Clause 1 stand part.
Question is that Clause 1 stand part. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Clause 2.
Beg to move that Clause 2 stand part.
Question is that Clause 2 stand part. All honourable members in favour, please say aye. All honourable members against, please say no. Methinks the ayes have it.
Clause 3.
Beg to move that Clause 3 stand part.
Question is that Clause 3 stand part. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Clause 4.
Beg to move that Clause 4 stand part.
Question is that Clause 4 stand part. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Clause 5.
Beg to move that Clause 5 stand part.
Question is that Clause 5 stand part. All honourable members in favour, please say aye. Aye. All honourable members against, please say no. Methinks the ayes have it.
Clause 6.
I beg to move that Clause 6 stand part.
Question is that Clause 6 stand part. All honourable members in favour, please say aye. All honourable members against, please say no. Methinks the ayes have it.
Clause 7.
Beg to move that Clause 7 stand part.
Question is that Clause 7 stand part. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
First schedule.
Madam Chair, I beg to move that the first schedule be the first schedule to the bill.
Question is that the first schedule be the schedule to the bill. All honourable members in favour, please say aye. Aye. All honourable members against, please say nay. Methinks the ayes have it.
Second schedule.
Madam Chairman, I beg to move that the second schedule be the second schedule to the bill.
Question is that the second schedule be the second schedule to the bill. All honourable members in favour, please say aye. Aye. All honourable members against, please say no. Methinks the ayes have it.
Report.
Madam Chair, I beg that you do now report to His Honour the Speaker the passing of one bill in committee.
Question is that I now report to the Honourable Speaker the passing of one bill in committee. All honourable members in favour, please say aye. Aye. All honourable members against, please say nay. Methinks the ayes have it.
Chairman of Committees has reported the passing of one bill in committee.
Mr. Speaker, I beg to move that this bill be read a third time.
Question is that this bill be read a third time. All those honourable members in favour, please say aye. Aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that this bill now do pass and be cited as the Supreme Court of Judicature Amendment Act 2019.
Question is that the aforementioned bill be passed and so cited. All those honourable members in favour, please say aye. Aye. Those against, please say no. Me think the ayes have it. This bill is so passed and so cited.
Mr. Speaker, that brings us to the end of government business for the day. I beg to move that this Honourable Chambers be adjourned for sitting until February the 12th, Tuesday, February the 12th at 10 o'clock in the morning.
Question is that this Honourable Chamber be adjourned until the 12th day of February at 10 a.m. in the forenoon. All those honorable members in favor, please say aye. Aye. All those against, please say no. Me think the ayes have it. This honorable chamber is adjourned until the 12th day of February at 10 a.m. in the forenoon.